Okay, let's dig into the rules for each type. Personal service, direct delivery, signed acknowledgement. What if the defendant refuses to sign?
Good question. Sedler explains that refusal doesn't automatically kill the service. The serving officer just reports the refusal to the court. If the court believes the documents were physically handed over or offered, the refusal doesn't matter. Service is still considered effective.
So you can't dodge service just by refusing to sign the paper if they actually handed it to you.
Right. Now, there are also situations called assimilated personal service, where serving someone else counts as serving the defendant personally.
Like who?
Well, first, an agent the defendant has specifically authorized to receive service. Think of a foreign company doing business in Ethiopia. They might appoint a local agent for this very purpose.
Okay, a designated legal representative.
Exactly. But Sedler cautions, just serving any old business agent doesn't count as personal service under this rule, though it might be constructive service under a different rule. It has to be an agent specifically empowered for legal service.
Got it. What else counts as assimilated personal service?
Serving the defendant's pleader, their lawyer, essentially. If
Huh.
they've appointed a lawyer for the case, serving the lawyer or leaving the documents at their office counts as serving the defendant.
That makes sense, serving their legal representative. What about businesses like partnerships?
Article 98 covers that. If you sue a partnership firm, serving just one partner at the firm's main place of business counts as good personal service on all the partners, even ones living abroad.
That seems efficient, suing the business entity.
It is. The firm usually defends itself anyway. But, Sedler notes an exception. If the plaintiff knows the partnership was dissolved before the suit, they have to serve every individual person in Ethiopia they want to hold liable.
And they need to be told why they're being served.
Yes, written notice saying if they're served as a former partner, manager, or both. If no notice, they're just considered served as a partner.
Okay, specific rules for partnerships. What about corporations, bigger companies?
Article 97. You can serve the secretary, a director, or another principal officer personally, or you can deposit the summons at the registered office or main place of business, or send it by registered post there.
Several options there. Is there a preferred order?
The code doesn't explicitly say, but Sedler suggests a logical order based on effectiveness. Try personal service on an officer first, then deposit at the office, then registered post.
Makes sense. Try the most direct first. And if you're suing the government,
Article 96, subsection 3 says, serve the government pleader. If there isn't one appointed for that jurisdiction or case, the court has to figure out another way to serve the government.
okay, that covers personal and assimilated personal service. Now, on to the next realm, constructive service. Remind us of the basic idea.
Constructive service relies on serving someone closely connected to the defendant, assuming they'll pass the summons along because personal service wasn't possible. Sedler outlines three main types.
What's the first one?
This involves suits about a business or work where the defendant doesn't live in the court's jurisdiction. Service can be on the manager or agent personally running that business for the defendant at the time of service.
Okay, but there are conditions, right?
Oh yeah, several key ones. The suit must relate to that specific business. The defendant must live outside the jurisdiction, and service has to be on the actual manager in charge, not just any employee.
So if someone from Desi has a car accident in Addis, you probably can't just serve their unrelated business agent in Addis for the accident lawsuit.
Yeah. Exactly. Sedler uses a similar example. The lawsuit isn't about the business the agent runs. He also notes the code says a ship's master counts as the agent for the owner or charterer for business-related suits.
Very specific. What's the second type of constructive service?
This one is for suits about the defendant's immovable property land, buildings. If personal service is impossible and there's no authorized agent under Article 96, you can serve any agent in charge of that property.
Like a caretaker or property manager.
Right. Interestingly, unlike the business agent rule, the defendant doesn't have to be a non-resident for this one. But again, Sedler stresses this is only okay if personal service truly isn't possible. You can't just serve the watchman because it's easier if the owner is readily available nearby.
Always back to that hierarchy. Okay, what's the third and maybe most common type?
Service on an adult member of the defendant's family, Article 101. If the defendant can't be found and has no authorized agent, you can serve any adult family member living with them.
Again, no non-residency requirement here, just that the defendant can't be found for personal service.
Correct. And Sedler raises an interesting point about interpreting adult.
Yeah, what does he say?
He suggests that while the Civil Code might define minors under 18, For service, adult should probably mean someone mature enough to understand the summons and give it to the defendant. Not just any young child, someone responsible.
A practical interpretation focused on capability.
Oh.
Makes sense. Now, what about Article 109? Serving public servants or employees. You said that was sort of a hybrid.
Yeah, it's a bit unique. If the court thinks it's the most convenient way, it can send the summons to the head of the office where the defendant works.
The boss gets the summons.
Basically, yeah. 2 copies are sent, one for the defendant, one to be returned to the court, signed by whoever in the office served it, and by the defendant acknowledging receipt.
So you still get the defendant's signature, ideally.
Right. Sedler notes it's not strictly constructive service because there's no explicit rule you must try personal service first, but it uses an intermediary, the office head. He suggests this was likely useful if home addresses were hard to pin down, but workplaces were known. Because it results in signed proof, it's often treated like strong evidence of service.
A practical solution for certain situations. Does constructive service always require a signature from the person receiving it, like personal service?
Yes. Sedler emphasizes that whenever constructive service happens under Articles 99, 100, or 101 serving a business agent, property agent, or family member, that person must sign an acknowledgement on the original summons. Same purpose, proof of receipt.
Okay, so what if none of this works? You can't find the defendant for personal service, and none of the constructive service options apply or are successful.
Then the serving officer has to return the summons to the court unserved, and they must include an affidavit, a sworn statement explaining why service failed.
And what does the court do then?
This is when Article 105 kicks in. The court can then authorize the less direct methods, substituted service and service by registered post.
So these only come into play after the preferred methods fail. Does Sedler have a preference between postal service and substituted service?
He definitely does. Although Article 105 mentions both, Sedler argues strongly that service by registered post should generally be preferred over substituted service like newspaper ads.
Why?
Because the whole point is to give the best possible notice. He reasons, quite logically, that someone is much more likely to actually receive a registered letter sent to their address than they are to spot a notice in a newspaper. So try post first, then consider substituted service as the real last resort.
Okay, that logic holds up. Let's look at service by registered post under Article 106. When can it be used?
It can be used instead or in addition to substituted service under Article 105. But Sedler is clear it cannot replace personal service if personal service is possible, nor does it replace constructive service if that's appropriate and feasible. It's the next step down after those fail.
So, still respecting the hierarchy. How does it work? Send it by registered mail.
Yeah. Addressed to the defendant or their authorized agent at their usual home, business, or workplace. If the post office gets a signed acknowledgement back, that's considered prima facie initial proof of service.
What if they refuse the mail?
If the postal worker notes the refusal, that also counts as prima facie proof of attempted service.
So refusing the registered letter doesn't get you off the hook.
Not automatically, but, Sedler adds, the defendant can always come to court later and try to prove they didn't actually get it, or the signature wasn't theirs, or it was forged, etc. They have a chance to rebut the presumption.
Okay. What if the defendant lives in Ethiopia but just outside the area the court covers? Different jurisdiction.
Article 107 handles that. The issuing court can send the summons by officer or post to the court in the area where the defendant lives or works. That local court then tries to serve them personally.
When reports back.
Yes, they send the summons back to the original court with a record of what they did, whether they succeeded or not. It's a system of intercourt cooperation.
Efficient. Okay.